Okay, Chapter 5 is the real estate brokerage activities. And there's going to be a lot of stuff in here about the real estate broker and how the broker operates their office. So let's just kind of work through this. It's things that you're going to have to know for your state examination. To begin with, a broker's office. Let me define that for you. A broker has to have an office. Every broker has to have an office somewhere. It does not have to be in Florida. And by definition, an office is at least one enclosed room of stationary construction where negotiations take place and records are kept. Now, there are other offices a broker may have, but they have one main office only. Now, on or about the entrance of that main office and any subsequent office, there has to be an official sign. Now, let me say this one more time. It needs to be on or about the entrance, which means it can either be on the exterior or directly on the interior, where any normal person walking in knows they're dealing with somebody in real estate. And what has to be on that sign? There are some components. First of all, it has to have the name of the broker on it. If that broker is doing business in some type of a business, it has the name of the brokerage entity. And it has to have the words licensed real estate broker. So 3 components: the brokerage company, the name of the broker or brokers, and the words licensed real estate broker. Now, licensed real estate broker can be abbreviated to some degree, LIC, but they want you to spell out everything else. The question may be, can an associate, either a sales associate or broker associate, can they be on this official sign? Well, the answer is they could be, but typically they're not. But if they are, they have to be segregated from the broker with their license status put on it. Now, the subsequent offices that I was talking about could be a branch office. Now, a branch office can be located anywhere. It has the same requirements as a broker's primary office. In an earlier chapter, I mentioned that if a broker moves their main office to a new location, they've got to notify the Division of Real Estate within 10 days, or that license is going to cease to be in force. Branch offices don't work that way. A branch office is a standalone, and branch offices are not transferable. So if a broker wanted to go in and open up a branch office and later decide to move that branch office to another location, all they'll be doing is simply opening up a new branch office. The bottom line is you can't move a branch office, so there's no applying with the division about that movement or that change of address. Don't confuse a branch office with a temporary shelter. Now let's talk about a trailer. Let's talk about a construction trailer. If a broker is operating at a construction site and that contractor puts a trailer on the site where all their tools are kept and other things are kept, and agents go into that trailer to do paperwork and do other stuff, I think the easy way to remember this is that location is used for other things other than that real estate office sitting in it. Now, they may sit in there with a buyer, maybe, but by definition, one enclosed room of stationary construction where negotiations take place and records are kept. And that's what we're looking for. Chances are that construction trailer is not going to be considered a branch office and will not have to be registered with the DBPR. Now, if a real estate broker moves a trailer onto a sales site to sell a development project, where nothing takes place in that trailer except negotiations and where records are kept, and it's literally a broker's office, I can tell you now, that's going to have to be registered as a branch office. Advertising is also a service of real estate that brokers have to be very cognizant about. A lot of brokers get in trouble for false and misleading advertisement. And just remember that it's going to be the broker who's going to be ultimately responsible for all advertisement done. And let me make a comment about how this comes about. First of all, a blind advertisement. You run an ad in a magazine or a newspaper, or even on your business cards, and you don't have the name of the broker or the brokerage entity on it, whichever one they're operating out of, That's considered to be a blind ad, and that is illegal. And let me go back one more time so that we understand this. If I'm David Collins and I'm a sole proprietor, and I'm simply doing business as David Collins, licensed real estate broker, the only thing that has to be on my official sign is David Collins, licensed real estate broker. But if I'm David Collins and I formed a corporation called ABC Great Realty Incorporated, my official sign would say ABC Great Realty Inc., David Collins, licensed real estate broker. It's critical because ABC Great Realty is going to own those listings. ABC Great Realty is really the entity that I'm operating out of. So that blind ad has to have whatever entity that I'm operating out of. A point of contact has to do with internet-based advertising. And there's a list of things that have to be done besides just the name of the brokerage entity. In addition to the name of the brokerage entity, you're going to have the address. It's supposed to be both the physical and mailing address. You're going to need an email address, and you're also going to need a telephone number. And that is on any internet-based advertisement, and I'm going to tell you that includes Facebook, LinkedIn, or any place else that we're advertising. Florida has a do not call list, and so does the federal government. So if we're doing cold calling, we have to be very cognizant about the rules about that. There are fines that can occur, but let me break these down. To begin with, if you're calling for sale by owners, the state of Florida, the Florida do not call list says that if a for sale by owner gives out their telephone number or email address, they no longer can hide behind the protection of the do not call list. So you can call them. But if they're on the federal do not call list, it doesn't matter, you still can't call them. Like I said, there's going to be some serious fines, and those fines keep going up, by the way. I think recently I saw on the internet that the federal do not call fine has gone up to $40,000 now. As far as handling of escrow accounts, what an escrow account is a place where we put somebody else's money. And let me kind of separate this out for you, because in today's real estate world, brokers have two avenues. A broker can either be the signature of an account, or the broker can be a non-signature of an account. And what's the difference? If the broker is a signature of an account, that means it's that broker's account, which means that that broker collects the money and puts it in their own escrow account. That means that broker can write a check on that escrow account. If the broker is not signature, that means they're putting it in a place where they cannot get to the money. They can't write a check in it. So what's the difference? If the broker is a signature, they can put it in a commercial bank, a credit union. They can put it in any number of places, an S&L, where they can write a check. Where they can't write a check is a title company or an attorney. So there's two different places that a broker can place escrow. I think it's important to note that brokers cannot commingle funds if they're holding escrow in their own account. And what that means is they cannot take somebody else's money and put it in their operating account. Now, I will say this, though, that if a broker opens up an account in their own name, they can put up to $5,000 if it's a property management account, and they can put up $1,000 if it's a sales account. But again, that's not considered commingling. It's simply money put in there to be able to maintain that account. Also remember that when we talk about putting money in escrow, money has to be placed in what we call immediate, according to the 61J2 rules of the Florida Real Estate Commission. A sales associate has to deliver escrow to their broker or where their broker designates them to put it within 1 business day of the date that the contract says they collected it. The broker then has to have it put in escrow within 3 business days of the date that the contract said that it was picked up or delivered. In other words, it's not 1 business day plus 3 business days. It's a grand total of 3 business days from the date that the contract says that the money was delivered, that money has to be in escrow to protect the broker. Now, what happens if a contract is written where the buyer writes a check out directly to a sales associate? I know that's happened before. All they have to do is endorse the check over to their broker. Easy do. Also, let me say this, that we can collect both promissory notes and post-dated checks. It's not something we like doing, but if you do, make sure that you get the seller's permission prior to taking and delivering that money to escrow. When a broker has conflicting demands, and let me tell you what that is, both the buyer and the seller want the deposit. This is going to be an issue, but once again, let me separate things. If a broker is non-signature, this is a title company's issue and a title company's problem. The broker does not have to necessarily get too involved in that, except for record keeping. If, however, that broker is the signature of that account, now certain procedures have to take place. First of all, they have to notify the Florida Real Estate Commission within 15 business days that they have a dispute. They have a grand total of 30 business days to get that dispute resolved in its entirety, or take one of 4 steps to get it resolved. Those steps are to file with the Real Estate Commission for an escrow disbursement order. In other words, ask the commission what to do with the deposit. They can also ask the buyer and seller to mediate, and that is to go to a third party and help them negotiate a settlement. They can ask the parties to arbitrate. Now, arbitration is where a third party makes a decision for them. Not a lot of people like arbitration. The last place to go, and the last place anybody wants to go, is litigation. And that's where the parties simply, you put the deposit in the court's hands and say, hey, they're going to litigate, courts, you take over, tell them what to do. Rental information is going to be an issue that you're going to have to deal with as well. And all rental information is some brokers sell rental lists to potential renters, and they enter into a contract saying that if you rent one of my properties, what I'll do for you is I'll give you a discount on the first month's rent. But what they do is they collect that discount up front. The easy way to understand this, the broker contacts the rental property. The owner says, I'll give you $300 discount on the first month's rent if you rent it for me. The broker goes back to the renter and says, I'm going to sell you this list for $300. And by the way, if you rent it, you're going to get a $300 rebate out of the first month's rent. They'll give you a discount. Now here's what the contract has to say. If that tenant chooses not to rent for whatever reason, that broker has to be prepared to give them back 75% of everything they collected, of the entire deposit they collected. But they have to make their demand for the refund within 30 days. If the list was inaccurate materially, that broker's got to be prepared to pay back 100% of what that person paid for that list. And again, that demand has to be made within 30 days of buying that list. If they go beyond 30 days, they don't have a claim on that deposit. And if the broker doesn't have the money to make that refund, that's one of the few first-degree misdemeanors that the state of Florida will impose on a broker, which could carry up to 1 year in a county jail and or up to a $1,000 fine. Real estate commissions are going to be important. Just remember that we collect our commissions based on a transaction, and every time that we negotiate a listing contract, we negotiate our commissions. As far as sharing commissions, however, a sales associate cannot share a commission with another associate. A broker can only pay a sales associate that is under their license. Another broker can't pay some other broker's sales associate. So the way it flows down is broker A has an agent under them, they can pay that agent. Broker B has an agent under them, they can pay that agent. They can't crisscross. They can only be paid by their broker. And there's two agents working on the same transaction for the same broker. Those agents can't pay each other. It all has to come from the broker. As far as changing your employers, just make sure that you need to notify the commission or the Department of Division of Real Estate within 10 days of your change. The different types of business entities are going to be important. We all know what a sole proprietorship is. That's an individual that goes into business for his or herself, hopefully for a profit. A general partner, or two or more people that go into business for profit, I hope. But here's the deal if it's a real estate brokerage general partnership. First of all, a general partnership is one of those few business entities owned by more than one person that doesn't even have to be in writing. In fact, it's the only one that a handshake is all that you need. But I think what's more important than that, remember that sales associates and broker associates cannot be general partners in a real estate general partnership real estate company. Now, let me make a comment about an ostensible partner. When two brokers have offices in the same facility and they're sharing maybe a secretary, if the public perceives them to be partners, guess what they are? They're partners. That's an ostensible partnership. It's one out of circumstance, not choice. I'm going to give you an example. I had an office that I was in as a broker. I had my official sign up. Another broker moved into the office next door to me. He never put his sign up, but he had customers coming in. Those customers may have perceived us to be together. That created for me an ostensible partnership, and I could have been liable for his actions. Corporations are also very popular for brokers, but let me say this. They're made up of stockholders. Anybody can own stock in a real estate brokerage corporation, including sales associates and broker associates. But a broker associate or sales associate cannot be an officer or director of a real estate brokerage corporation. And the last thing is a limited partnership. Now, this is made up of both general partners and limited partners. Once again, a sales associate cannot be a general partner, but a sales associate can be a limited partner, because remember, a limited partner is simply a person that puts up and shuts up. They don't participate in the business. As far as trade names are concerned, only brokers can use a trade or fictitious name. Sales associates have to operate in their real name, and they have to register with the Division of Real Estate, the DBPR, in their name and be licensed in that name. Some of the corporations that exist that cannot broker real estate you need to be aware of. I'd look through the list in the book. Your corporation sole, which is a church, is one of them. Your joint ventures, your business trust, your unincorporated associations. I would know the difference between those that can broker real estate and those that can't broker real estate. And that's all that I have for Chapter 5 to review with you right now. So what I'm going to do is I'm going to jump straight into my review of Chapter 5. Chapter 5, the real estate brokerage activities. Every broker must have an office somewhere. It does not have to be in Florida, but it still has to be registered with the Department of Business Professional Regulations of Florida. The required information for the official sign, it has to have the name of the brokerage entity that you're operating out of. It has to have the name of the broker or brokers, and it has to have the words licensed real estate broker. If an associate's name is on that sign, they can do that, but it has to be segregated from the broker with their license status next to their name. A branch office is not transferable. And remember that the registration period is going to be good for 2 years. And by the way, that means that you can move out of and back into a branch office without any registration with the DBPR. Construction trailers are typically considered to be temporary shelters. A broker's ultimate responsibility is going to be for advertising. They're going to be ultimately responsible. An ad without the name of the brokerage entity is called a blind advertisement. The federal no solicitation prohibits cold calling for FSBOs. Immediate for delivery of escrow means within 3 business days of the date that the contract says the escrow was delivered. The settlement procedures for conflicting demands include mediation, arbitration, litigation, and the escrow disbursement order from the Florida Real Estate Commission. 10 days to notify the Commission of resolution if a dispute is settled early, by the way. Rental information list. If the information is correct, the broker's got to be prepared to give back 75% as a refund. If it is inaccurate in any material way, 100% refund is going to be required. But remember, the demand has to be made within 30 days of contracting. General partnerships, remember, 2 or more persons, 1 active broker. A sales associate or broker associate cannot be a general partner. A corporation made up of stockholders has to have at least 1 active broker. Again, sales associates, broker associates cannot be an officer or director of a real estate brokerage corporation. Again, they can be a stockholder. And that's all I have for Chapter 5's review.